Morning, everyone, and today's lesson is the last part of our lesson on our series of lessons on the 2019 amendments to the revised rules of civil procedure. Now, as said during the last lesson, today's lesson would be on summons, motions, pre-trial, and trial. Now, usually it is the court or the regular procedure, it is the court that serves the summons to the defendant. However, upon authorization by the court, and there should be an ex parte motion or a motion filed by the plaintiff, authorization for the plaintiff to serve summons to the defendant may be done, and it should be done together with the sheriff. And if the person or the defendant is outside the judicial region, the plaintiff shall be authorized to cause the service of summons. Now, what if there's a misrepresentation on the part of the plaintiff that summons was served to the defendant? If later found out, the court shall dismiss the case with prejudice. So there should be no refiling because of the misrepresentations. Also, proceedings shall be nullified and the plaintiff shall be meted with appropriate sanctions. So this is not tolerated by our laws. Now, when is there substituted service of summons? Now, if the defendant could not be served personally after 3 attempts on 2 different dates, service of summons or substituted service of summons may be done. And how is it done? By leaving copies of the summons at the defendant's residence to a person at least 18 years of age and of sufficient discretion residing therein. So that person should not be a minor, of course, and it should have the necessary or sufficient discretion. Now, if the defendant could not be served also, then copies would be left to the defendant's office or regular place of business with some competent person in charge thereof. So you have to take note of this. And substituted service of summons may be done if there is a refusal also of entry with any of the officers of the HOA or Homeowners Association or the condominium corporation or its chief security officer in charge. So you have to take note of this new ways of substituted service of summons. Now, also by sending an electronic mail to the defendant's electronic address if allowed by the court. So there should be consent by the court. Now, there are 2 types of motions, and the good thing about the amendments is that there is a list of these 2 types of motions, the non-litigious and the litigious motions. Now, it gives you the example here, the issuance of an alias summons, the extension to file an answer, postponement, issuance of a writ of execution, and also non-litigious motions include the writ of possession, an order to direct the sheriff to execute the final certificate of sale in case of foreclosure, and it shall not be set for hearing and shall be resolved by the court within 5 calendar days from receipt. What about litigious motions? Litigious motions include the bill of particulars, the motion to dismiss, new trial, consideration, execution pending appeal, and also the amendment after responsive pleading has been filed and the cancellation of a statutory lien of a property, or for an order to break in or a writ of demolition, intervention, and also the judgment or the allowance of judgment on the pleadings, and having a summary judgment and demurrer to evidence, and also declare the defendant in default. Now, motions must be or the opposition to the motion must be, if the motion is litigious, then opposition may be filed within 5 calendar days from receipt, and the court must resolve the same within 15 calendar days. Take note of the calendar days from receipt of the opposition or upon the expiration of the filing of the period or the period of filing the opposition. Now, the motion to dismiss is not allowed except there's lack of jurisdiction, another action is pending or les pendens, or barred by a prior judgment like res judicata or by a statute of limitations. Now, another prohibited motion is the motion to hear affirmative defenses, motion for reconsideration in case the court acted on the affirmative defenses. Affirmative defenses, again, is included in the answer, and motion to suspend proceedings without a TRO or temporary restraining order or injunction by the higher court, and motion for extension to file pleadings, except there is that one like the 30-day exemption or 30-day extension, and there should be a only one postponement according to Rule 11, Section 11, and the motion for postponement, which could be intended or is intended to delay the proceedings. Now, I'm about to continue with pretrial. However, my computer is almost empty. Like the battery is almost. It says it's low battery, and anytime it could be turned off. So I need to end the lesson now, and we have to extend the lesson because of the limited time, and I have no way to charge now. So thank you so much for listening, and I hope you check on our Facebook page, share it to your friends and the persons who you think could relate, and also our YouTube channel for our videos and a better or smoother navigation, and also our website, which is a constant or which is a work in progress. Thank you so much. Thank you. And I hope you look forward for the lesson and part 4 of the lesson of the part 4 of the series on trial or on pre-trial and trial. Thank you so much. Thank you.